This is estate planning lawyer Michael Pevney, and in this video we're going to talk about whether or not you have to tell your mortgage company if you put your home inside of a living trust. But before that, if you are interested in estate planning information, please follow this page for more information. Make a comment or ask a question in the comment section, and I'm usually able to respond. Now, for most of my clients, I create for them a trust, a revocable living trust. And what that means, that type of trust, you or you and your spouse typically have complete control over everything inside of that trust. Now, I practice in California, and in California, people's most valuable asset, sometimes it's a retirement account or a 401k, but very often it's their home. Homes have very high values in California, and in the particular area that I practice, average home value, average home sale is over $1 million. So there's often big mortgages on that house. And a lot of times I get the question, is my mortgage going to be due? What's going to happen with the mortgage after I transfer this home into the name of the trust? Now, there's a lot of reasons that we want to put a home inside of a living trust. The big reasons are cost. We want to avoid the high cost of probate. Control. We want to control what happens to that house after we've passed away. Third, we want everything to be private because things inside of a trust pass privately outside of the public probate process. And time and hassle. Probate often takes a long time, 1.5 to 2 years. So we almost always want to put the house inside of the trust. But if that house has a big mortgage on it, the mortgage company cannot enforce a due on sale clause. In fact, you don't even have to tell the mortgage company that you put the house into a trust. Now, you do have to file a deed with the county clerk's office, so they're going to know that there was a transfer in ownership, but that's typically not going to affect property taxes or anything like that. So you do not have to tell the mortgage company, and there is a very specific law telling us that we don't have to do that. It is called the Garn St. Germain Act. Weird name, those are the two people, Garn and St. Germain. I guess they were the names of the congressmen that wrote it. 1982, and one of the provisions of that is if you're putting your primary residence into a trust, if you live there or you and your spouse live there, and you put it into a trust, that you have complete control over a revocable living trust that you are the trustees and the beneficiaries of, the mortgage company, the bank, cannot demand full payment of that mortgage. Even if there is a clause somewhere in that mortgage, it is unenforceable. If they tried to sue you, which doesn't happen, they can't collect. So, because you have complete control over it, you can put it inside of the trust without any penalty. And sometimes I get other questions like, what are the tax implications of putting a house inside of a living trust? Sometimes, they'll say, do you need a federal tax ID number? One of these special things that we'll have to create for an entity. And if we're talking about a trust, a revocable living trust while you're alive, no, you do not need a federal tax ID number. You don't have to tell the IRS that you have a trust. The federal government doesn't need to know about it. While you're alive and while you have complete control over everything. Now, when you pass away and you want to really control this house from beyond the grave, and maybe you want to use it as a rental property and it's going to be basically an ongoing business, yes, you'll have to get a federal tax ID number. But while you're alive in California, your property taxes aren't going to change. Nothing's going to happen with capital gains. You do not need a federal tax ID number. Sometimes, if you want to open a bank account in the name of the trust, just like any bank account, they're going to need a tax ID number if you use that, or if you want to do that in the name of the trust, you just give them your social security number, just like you'd have to do if you opened a personal bank account. The trust, while you're alive, does not need a federal tax ID number. So, when you put your house that you live in into a revocable living trust, the mortgage company cannot demand full payment of that mortgage, even if it says so inside the terms of the loan, because of the Garn St. Germain Act of 1982. If you have any questions about this or anything else related to estate planning, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. Subscribe to this channel for more estate planning information. Ask your question in the comment section, and thank you for watching.